Good morning, everybody. Welcome back to Law and Crime. I'm Jesse Weber, and thanks for joining us here on the program. We have 3 live trials today, a lot to get through, so let's get started. Now, first, all right, let's break this down. Joining me now is juvenile judge and trial attorney Judge Ashley Willcott and trial attorney Alison Currie. Great to have you both here. Judge, I want to start with you. Do you agree with the prosecution that the case is filled with overwhelming evidence against the defendant?
Well, here's why I think that it is, because, and I'm sure you're going to get into this a little later, when their son testified in this case, he made very clear they were the only ones on the farm at that time. And so by virtue of that, and if you have testimony, which they did, about 2 hits in the back with this rake, and she was struck 2 times, I think that it eliminates any other possibility based on the circumstantial evidence.
Alison, what do you think about the comments? So him, making those comments that he first thought it was an accident, and then also the search history. Why is someone looking up how to, kill or get rid of a wife that's having an affair? That doesn't look so great for him. What do you make of those?
It doesn't look so great for him, but the search history stuff is maybe the least persuasive part of this case for me. I mean, if you looked at my search history, I may have looked up some weird things, and it doesn't mean that I've ever murdered anybody with a corn rake, especially because some of the searches were a little bit more incriminating than others. I think one search was for how to kill an unfaithful wife, but then one was what happened to cheating spouses in ancient Aztec times. Maybe that's a cover-up. Maybe he added the historical language to make it less literal to his case, but I don't know if he's thought it through that much. The search history doesn't tip me over as much as some of the other details of this case.
Judge, the thing that's strange is a man's going to really, and this is what the defense tried to say, he's going to kill the mother of his children. He's just going to do this. And by the way, as you said, in such a way where it's clearly him. You use a corn rake right on the property. Who else would do it? If you're going to get rid of your wife, is that the way that you would have done it? So that's the interesting part here, is that if we're trying to talk from a practical common sense point of view, does it make sense that he would send his teenage son to go check on his mother, who he knows he just murdered? I mean, you tell me if that makes sense to you.
Well, to me, it sounds more like if he actually did it, or if he's convicted of this, that it would have been in the heat of the passion, right? That this would have been something he did in the middle of a fight or an altercation, couldn't control himself, ended up killing her. However, that's not the prosecution's argument. As you well know, it's that it was premeditated, that he planned it out. And it is really atrocious to think if he did, in fact, plan this out, if the jury finds that he did, that he would have done it when his son was home. His son would have found his mother. The other 2 kids were home. So you really have to hope that's not the case, but that's the prosecution's argument.
Alison, what do you make of the fact that he didn't lie to investigators about the accident? He felt that his wife might have fallen in the shed and landed on the corn rake, but that's legitimately what he believed at the time, given all the facts that he knew. What do you think about that?
I think it's a smart strategy. I think that the defense was going to have an impossible time overcoming the discrepancy between the 4 pokes on a corn rake and the 6 puncture wounds she had. And I'm imagining that that's what drove them over into accepting that it was a murder. I also totally agree with the judge that the prosecution may have overplayed the premeditation angle. And I understand that they're going for a, first-degree murder charge here, but heat of the passion seems more likely to me, especially because of if he did do this, then it was rather sloppy and not super well thought out. Maybe he took advantage of the fact that she was dizzy and weak from this surgery that they've been talking about that she had, where she was having these dizzy spells, and that gave him an opportunity. But I'm interested to see where the prosecution goes with this idea of planning and premeditation, given how it ultimately played out.
Yeah, I mean, the defense is saying that they have enough reasonable doubt here. And here's the weird part, Judge. We came into this case thinking that the strategy was to keep saying it was an accident. But then the defense conceded, and we're going to probably play this after our next break, they conceded that she was viciously murdered. They just didn't say who, and they said it's not our job to say who, but we can say that he didn't do it, or that the prosecution can't establish that he did it. What did you think about that?
Well, I think that the son's testimony, and I'm sure, again, we'll probably get into this later, but he, in fact, I think was some of the best evidence that he unequivocally says, and he never changed his story on this part, that no one else was on that farm. And so it's okay to maybe point a finger if other people are around, but how do you point a finger effectively as the defense when there's been testimony that no one else was there that day?
He testified yesterday that his father did leave where they were hanging out at one point. He left for a period of time, could have gone to the shed. It seems to suggest he could have gone to the shed and killed his wife, then went back to see the son, and then told his son to go check on Amy. So there's something interesting about that testimony. Let's take a break. When we come back, maybe we'll talk a little bit more about the defense, and we're waiting to go live in one of our first trials of the day. Stay tuned.